All right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
Melissa Goodrich, Wayne County Prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter.
I do see that the new charge is set for an arraignment on September 10th. It was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening.
Before we jump into the chaos you're about to witness, let me be very clear. This is not just another traffic stop gone wrong or a defendant having a bad day. What you're watching unfold is an entire belief system colliding head-on with the cold, procedural reality of the courtroom. Today's cases feature self-identified sovereign citizens, individuals who genuinely believe that by rejecting words, refusing consent, or declaring themselves a living man, they can somehow step outside the reach of criminal law. But here's the problem: courts don't run on internet theories. They run on statutes, jurisdiction, and procedure. And the judges in these courtrooms have seen every version of this playbook before. From refusing legal counsel, to rejecting a driver's license, to insisting that misused legal terminology can erase charges, every move we see today only tightens the system around the defendant instead of freeing them from it. And this isn't harmless posturing. These beliefs have real consequences: missed court dates, revoked bonds, new felony charges, and defendants walking themselves directly into deeper legal trouble. Watch closely how calmly and methodically these judges respond. No debates, no philosophy lessons, just law applied in real time. Because by the end of this video, you'll see exactly why saying "I do not consent" has never, not once, stopped a courtroom from moving forward.
That's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had to lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore, against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you. Ms. Gooders, people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court And this is not somebody else's, I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender 18.
Right here is the first unmistakable red flag. When a defendant announces they are a living man, they're not clarifying identity, they're declaring allegiance to sovereign citizen ideology. This belief system falsely claims that courts only have authority over corporate entities or legal fictions, not flesh and blood humans. The idea is that if they verbally reject that legal fiction, the charges somehow evaporate. But notice the judge's response: calm, controlled, and completely uninterested in debating philosophy. That's because jurisdiction doesn't depend on what someone calls themselves. If a crime is alleged to have occurred within the court's territory, the court has authority. Period. Judges hear this argument constantly, and it has never worked. What's fascinating is how quickly the court moves on. There's no outrage, no arguing, just a procedural response, and the case continues. And that's an important lesson. Courts don't argue belief systems. They document them and then proceed anyway.
These charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not receive to the, I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am, I don't consult to the proceedings, and I would like to say things. Charged for that, then what they're putting on me, they found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, man, this is gonna get thrown out because the officers were just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here, so when we have the hearing, all this can be.
This is where things quietly shift from entertaining to dangerous. The defendant refuses a lawyer, rejects a driver's license, and declines any prosecutorial offer. That's not confidence, that's isolation. Every safeguard the justice system offers is being waved away under the false belief that participation equals consent. Here's the reality: criminal courts do not require consent. You don't opt into prosecution. These questions from the judge aren't traps, they're opportunities. Legal counsel protects your rights. A license discussion may mitigate penalties. A plea offer can drastically reduce exposure. Refusing all of it doesn't make someone principled, it makes them vulnerable. And notice how efficiently the judge keeps moving. The system doesn't stall because a defendant refuses to engage. It adapts. Deadlines are set. Pleas are entered. The case continues with or without cooperation.
Brought forward for your preliminary hearing or for your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with these proceedings though, and I do not accept the terms, like.
Okay.
Yeah,
well, you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, ma'am. So okay. With what you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, like, I thought I had to deal with Fulton County on that instead of Clay.
You have, looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me? Like
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park,
yes, ma'am.
it is on or around July 28th it happened. So that is not the Fulton County one that appears to have happened around July 17th. So
So
there's,
that's Clay County
yeah, if the warrant was sworn out.
and all that. Now once they searched and seen I was clear up good, I know the officers, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck I was renting out at the time.
Mr. Whitlock, I'm gonna
That's
stop
what
you
I'm
there, because you're doing too much. You're talking about Fulton County. I was trying to let you go forward and
So
explain
I'm
it.
saying I need some professional help, like.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you could tell me, like, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There
But
was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am, but even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are next.
Here we hear the phrase sovereign citizens rely on most. I do not consent. But here's the truth: consent is irrelevant in criminal proceedings. Jurisdiction is established by law, not agreement. The judge handles this perfectly. She doesn't argue, she doesn't correct every misconception. She simply states the scope of the hearing and redirects the defendant to counsel, because arguing misinformation legitimizes it and courts don't do that. This moment highlights why self-representation paired with internet legal theories is so dangerous. The defendant believes he's protecting himself, but in reality, he's waiving opportunities to challenge evidence, negotiate charges, or preserve appellate issues.
That's not my name.
A Breland.
That's not my name. I'm here on special representation. I'm
Same as last defendant, Your Honor.
My honor, I'm asking.
Okay.
What is your status and what is your name? I'd like to know your name. I'd like to know your status. Of everyone in the courtroom, I would like to know what is your nationality and what is your.
So, deputy,
Yes, ma'am.
I would like to know your
so
nationality.
he has charges in jots and he has a paper charge. Let me see if they're the same warrant. And they're different warrant numbers. Okay. So I guess I do both sets. Let me see when these are.
Know your nationality. I would like to know if you're a U.S. citizen of the United States, and so what is your status? You're a U.S. citizen of the United States.
All right, hold on one moment, sir. Let me review the warrant.
Asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? Once again, my honor,
Is he deputy?
status
Say it
of
again, Your
everyone
Honor.
in the
Is
courtroom.
he injured? Is that why is he in a wheelchair?
Yes, ma'am.
I would like to know the status of everybody in the courtroom.
What we've seen today is a textbook example of how sovereign citizen ideology collapses under real-world law. Every attempt to reject jurisdiction, refuse consent, or outsmart the system only resulted in tighter procedural control, additional charges, and fewer options for the defendants involved. Judges didn't raise their voices, they didn't debate beliefs. They applied the law calmly, methodically, and consistently. And that's the ultimate takeaway here. Courts respond to filings, facts, and statutes, not performances or internet theories. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns that expose what really happens when legal myths meet reality.